Okay, we're starting 5 minutes late, but this is such a energetic, productive, and exciting discussion. We're going to go 5 minutes into the lunch period, and then you'll see everybody will be just talking. I'm Barry Scheck, co-director of the Innocence Project. I'll be moderating this panel. It's quite something. We have starting in order, and all of a sudden, everybody decided for a PowerPoint, Matthew is penalized, right? Because everybody said, I'm not doing one, then everybody eventually did one. But first is Brad Bridge, legendary defender here in Philadelphia. And before we had databases, we had Brad. Too much media. All right.
No, just mine.
We start talking on this? Okay. So we start with Brad Bridge, who is a one-person institutional defender over the years in Philadelphia, began noticing all the patterns of the corrupt police officers, and then, was a one-man mass liberation agent who was able to convert the arrests and convictions of these police officers into dismissals. And what we're going to do in this panel is go immerse a little bit more in the details of exactly how one gets that done. We'll start with Brad. Then we have Deborah Levi from the Director of Special Litigation, Baltimore City, the Maryland Office of Public Defender, star of wonderful BuzzFeed clip describing the exonerations that are beginning to occur in Maryland, a very tough jurisdiction in getting access to the information, and we're going to see how the arrest, indictment, conviction, and more coming of these officers in Baltimore is going to lead to something huge. Josh Tepfer from the Exoneration Initiative in Chicago has done this already with Detective Watts and a whole group of people. So he's going to explain exactly how that happened. And then Matthew Segal from the ACLU in Massachusetts, the architect of the Dukins and Farrick mass exonerations. And right now, you're like the Jordan Spieth of the group. You have the numbers, right? At a very young age, you're logging the greatest number of exonerations in history. So why don't we just begin? Everybody's going to try to take between 10 and 12 minutes. Then I'll pepper them with questions, and we'll open up the floor and talk a little bit more, of course, about building these databases.
Hi, everybody. Barry's actually incredibly generous. I think he spoke to my mom. No one ever does anything alone. It's been my experience. I work in an office that has 250 lawyers. We have a wonderful support staff, and no one ever does anything alone. And what I want to do is describe some of the stuff my office has done for the past 22 years. We don't have the numbers that Massachusetts does, but we have at least the longevity because we've been doing it for a while. So let me start back in 1995. I was actually at that time assigned half-time to appeals and half-time to death penalty cases when 5 police officers were indicted by the federal government for, among other crimes, planting drugs and other related nefarious acts. I went to Ellen Greenlee, my boss, who's subsequently retired but is here today, and asked to be unassigned from those responsibilities to pursue tracking down cases involving these police officers. And we did. We ended up throwing out, over the next few years, about 162 cases, convictions. From that I learned the following, and that's what I wanted to focus on today. And I put some really pithy things together in a PowerPoint, so allow me to indulge you with that and hopefully not bore you too much. 10 minutes is pretty quick anyway. There's a lot of ways that you get information about problems with police officers. Some of it is from newspapers. And this was an article that was on the Metro in Philadelphia. It had 16 police officers that they found had been arrested and charged with crimes. Based on that, we started to try to open up cases involving those police officers. Later on today, you'll hear from Barbara Laker and Wendy Ruderman, who got a Pulitzer Prize for their series in the Daily News, dealing with tainted justice, where they found information from a confidential informant who said that the police officer with whom he was an informant was encouraging him to fabricate evidence and testifying falsely in court. A couple days later, the probe widened in the Daily News. Turns out there's a lot more going on than just one particular informant and one particular police officer. Turned out to be a whole squad of police officers that were involved in that. And as a result, there was video that was demonstrated how the police officers went into bodegas, cut the cables so they wouldn't be photographed, and proceeded, at least from appearances, to steal all the items that were in the stores at the time as the owners were carted off in arrest. So you get information from some media. That's helpful. Here's a recent one where the District Attorney's Office in Philadelphia, and you'll hear from Larry Krasner later on today, where they had kept a list of tainted police officers, a do not call list of officers for which they had serious doubts about their credibility. The Daily News later on called it a naughty cop list, which I always thought is pithy. The DA's office subsequently disclosed that list in response to a subpoena from our office. We end up with a list that has 66 names on it, 29 of which seem to have issues regarding credibility, for which we're going to have to track down arrests by those officers. We're going to have to look at some 6,000, 8,000 cases over actually probably like the next 30 days to be able to, well, alternatively, we can just file 6,000. I've already had that conversation with the District Attorney's Office, whether they want 6,000 or they want some intelligence. I think we're going to opt for intelligence. So this is the sort of thing that we try to track down information. We also, from that, can also generate lists when we got information about police officers. The Philadelphia court system has a civil docket which you can get online and be able to get information about. Earlier, Mike Mellon talked about PACER. You can get the same things from federal databases and track down. The key, it seems to me, is the following, is you need to get some information. That's a good starting point. I've talked briefly here about what the Philadelphia media has done. The Philadelphia media is actually pretty aggressive and excellent, and it's helpful to be able to track some of the stuff that they do, but that's not sufficient. Mike earlier talked about how we want to be proactive, and earlier panel talked about how to get information from clients. The nice thing about working in a large public defender's office is we can set up a policy where anybody who talks to a client and the client reports something inappropriate or troublesome can route the information to somebody else who will look at it. So for example, a number of our clients were arrested for prostitution, and they explained that actually they got arrested because they actually refused to blow the police officer. And a number of them had exactly the same story, and after I heard the same story the fifth time, I contacted the FBI and subsequently Internal Affairs, and they set up a sting for the police officers, and there were 3 police officers that were captured in the sting, were ultimately suspended, not prosecuted, which turned out to be kind of a troublesome decision because they sued and got their jobs back. But what that demonstrates, I think, is that if you are in tune with your clients and hear what it is that they have to say, then it's helpful to be able to get that information. You can utilize it and track down things involving particular police officers. What we've done in our office is we've tried, and we're just starting it now, to have conversations with the District Attorney's Office about particular police officers that seem to be particularly problematic, either based upon information from our clients, information from the media, information from other sources that we generate. One of the reasons we're able to generate a lot of this information is Pennsylvania law is pretty favorable regarding our ability to subpoena documents to court. it wasn't by accident that Pennsylvania law was favorable. It was good litigation. There was a case in 1999, Commonwealth versus Mejia Arias, where we had subpoenaed for trial the internal police files of the police officers involved, and that was granted by the trial judge and decided not to quash the subpoena. The Attorney General's office took an interlocutory appeal, and we won that issue on appeal. So we have some favorable law in Pennsylvania regarding the ability to track that information down. And as a result, we've gone forward and moving and had a number of cases dismissed that started from internal affairs files that we got and stuff involving the media. Let me just kind of summarize quickly and then I will conclude. There were a number of police officers that were arrested back in 2012. And as a result, we've had over 1,000 convictions that were thrown out involving those officers. In fact, I had a conversation with the prosecutor's office before they actually went to trial, and we decided that actually whether they were found guilty or not guilty was really irrelevant to the question of whether there was a sufficient reason to reopen the convictions. That there was enough evidence to charge them was agreed by us, the prosecutor's office and the public defender's office, was sufficient to reopen the convictions, and consequently, when they were found not guilty, it didn't stall or change anything. We moved forward with what had been the plan we developed. We had information about another police officer who decided to protect a confidential informant by simply perjuring himself in court and providing false information, albeit for what he thought was an appropriate motive, but those that are involved in due process and truth thought it was actually problematic. And he was actually subsequently charged with perjury because it is a crime to testify falsely, even for a good reason, in your own mind. And so far we've had 107 convictions of the 580 thrown out involving that police officer.
So in regard to those particular cases, I think it's of note how, and even before the election of Larry Krasner, right? How were you able to get them dismissed? Did you have to go and look individually at each particular case and make a showing that the officer's testimony was material and look at all the facts of the case? Was the burden on you? Did they come forward with it, or was it something much faster?
Well, unfortunately, it's not faster. What we did over the years is we've worked out the following system, and we've had 22 years to come up with it, but faster is probably better. We would generate whatever the list of cases, and we'd file post-conviction petitions alleging after discovered evidence based on whatever these new facts are. Then we would sit down with people in the prosecutor's office and go through cases one by one and determine two questions. Question number one, was this particular police officer that is agreed upon as being corrupt, was that person involved in an integral way with the case? Were they the affiant in the warrant, the search warrant? Were they the basis for probable cause? Did they actually seize the drugs? Could the case actually be put on in good conscience without that officer? That was question number one. And question number two was, did the particular case that we're trying to reopen arrive at a relevant time frame for the particular police officer's corruption?
In other words, when the period of time when everybody agreed the officer was corrupt.
Right. So, for example, in the cases where there was a federal indictment, we initially used the oldest date in the federal indictment, which was February of 2006, and we said, okay, February 2006 to the present, all those cases are bad. Cases in 2005 or beyond, no, unless I had some sort of evidence and I didn't have any evidence. What happened subsequently is in their trial is one of the police officers testified against them, and he said, yeah, by the way, we were all corrupt back 2001, 2002. So a number of cases that were in the 2001, 2002 to 2005 that I had the petitions dismissed, the petitions I had filed, I had lost, we refiled because of new information that came up. Faster would be better, particularly when we now have 8,000 cases we want to look at in the next 30 days.
That would be fast. Debbie.
Let's see if, do you want to ask or can I?
No, go right ahead.
Where's Steve? When I need him to start my PowerPoint. I have no idea how to do this, but. Oh, can you change to the next one? It's already up, it's already loaded, I just need to close his. Okay. So I'm Debbie, I'm from the Office of the Public Defender in Baltimore City in Maryland, and while somebody's changing over the PowerPoint, I'll just say that I'm honored to be here today. I feel like a baby in terms of mass exoneration in relation to all the people who are in the room. When I was in law school and I got really inspired to be a public defender, I read Peter Neufeld and Barry Scheck's book, Actual Innocence, and I was floored and just so inspired by their work. And when I got a phone call the other day from Barry Scheck on his cell phone, and I looked over on my bookshelf, I was like, holy freaking shit. Barry Scheck on his cell phone. So I'm so honored to be here with the both of them. Pardon my language, but most of us are defense attorneys. I'm also to look around the room and see law enforcement here. And I know that there's prosecutors. Raise your hand if you're in the room and you're a prosecutor or a former prosecuting association. Thank you for being here today. And raise your hand in this room if you're from law enforcement. I see several people, at least more than I've ever seen at any conference I've ever been to, people from law enforcement here today. And it's incredible to me that we're all here today, willing to take the time to travel to be here. This is something preventing wrongful conviction that we all believe in. Right? None of us went to law school or the police academy to wrongly convict a human being ever in a day in our life. At least I don't think so. I don't even think dirty police officers woke up one day wanting to be bad police officers, right? We all have the same goal, to clean the police departments, to make safer streets, and to build community relationships. So thank you. Round of applause for all the people from the other side. Talk really briefly about what's going on in Baltimore, and sad to say, it's what's going on across the country in Chicago and in Philadelphia. And the story that Brad just told, that there was a trial for corrupt officers. In that trial, they learned that the corruption dated back much earlier. Very, very sadly, the same exact thing just happened in Baltimore in February of 2018. So in March of 2017, well, originally 7 officers from the Gun Trace Task Force in Baltimore were indicted for racketeering, corruption. Later, Thomas Allers, who worked with them, became the 8th indicted officer in that group. This is what the BBC wrote about to be inside one of America's most corrupt police squads. When you read the statement of facts that attach to the guilty pleas filed in federal court, it reads like a terrible crime novel. They robbed, they kidnapped, they put on their masks, they pulled up, they hucked people out of their cars. In fact, they were involved with a vicious car chase that led to the death of an older man whose son was a police officer. When they went to search the car and they didn't find anything, this was one Wayne Jenkins, the most notorious of the crew in 2010, 5 years before the first date of the indictment. He couldn't find any drugs in the car, so he picked up the phone and he said, "Hey, Sarge, bring the shit." And the Sarge showed up and put the drugs in the car. And then they wrongly convicted Umar Burley and Mr. Matthews, whose first name escapes me. So this type of corruption started with a few officers in different areas of the Baltimore Police Department and grew over time to be truly some of the most corrupt and brazen conduct that you might come across. They stole $200,000. They would then, from a safe where they would put GPS trackers. In fact, how it started was Baltimore County cops had a bunch of heroin deaths, and they were tracking a car, and after a search, and they arrested somebody, they went underneath the car to remove their GPS tracker, and they were like, holy crap, there's another one. Well, they put all the names for the drug dealers who they were tracking in some fancy database that law enforcement uses, and they were like, there's nobody else supposed to be tracking these people. Who could it be? So they subpoenaed the name of the GPS tracker company, and it came back to the name John Poole, the only member of the Gun Trace Task Force who wasn't indicted. And they put a wire on these cuffs, and they found out that they were involved in this intensely corrupt ring. At the end, by the time it was over, Wayne Jenkins, the leader of the Gun Trace Task Force, had purchased and he got arrested with this huge bag with masks and axes and a machete. They would pull people over unjustly. Anyway, it was a bad day for Baltimore when the indictments came down. It was a good day for the Office of the Public Defender because we knew, for us, that our clients' stories were finally validated. Right? That what for years had been hearing about illegal arrests and theft and unconstitutional practices, finally people would start to listen to us because of the indictments. During the trial, where the corruption came out, we had a bail bondsman testify. Over the course of his experience with Wayne Jenkins, he stole over $1 million. This is to the backdrop of what was already going on in Baltimore in 2015. The riots of Freddie Gray were tearing the city apart. Incidentally, you'll see these officers in front of the CVS. This became, for our public defender clients, a big piece for us because people were rioting and looting and taking prescription drugs from this little pharmacy inside this dilapidated town, and it was so horrible that you would think that our clients would do that, except we learned in the trial that Wayne Jenkins walked out of that CVS with 2 huge garbage bags full of prescription medication to take back to his friend's house and store in the shed. So it actually wasn't really our clients, it was actually the police officers who were charged on that day with protecting the citizens of Baltimore. It was really almost one of the most tragic things we learned. The city was literally burning down in 2015. In 2016, the Department of Justice report came out that said Baltimore had a pattern and practice of unconstitutional practices, illegal stops, searches, arrests, excessive force, discriminatory practices. For those of you in the room who are public defenders, these are the stories that you hear from your clients all the time. It's what we heard from Mary, Tara, about connecting with your clients. Sorry, Tara. These are the stories that you hear from your clients all the time, and for us it was in writing. After the indictments for the gun trace task force, in, I think it was, March of 2017, we uncovered with the new technology for body-worn camera. This is a video that we released through our office. It shows a Baltimore police officer and his colleagues planting evidence on one of our clients and then laughing about it. Right? So even though things were really in turmoil in Baltimore, it wasn't getting any better, and it today probably still isn't, unfortunately, getting better. We're working to make it better. And how do we work to make it better? What happens today, and I'll go back for 1 second before I put that poor former officer's name up on the board. He earned it, I didn't do it. So what everybody's talking about today, and Michael is so impressive in Philadelphia collecting stats and going backwards and mining data, and that's wonderful. I'm a lawyer, so I can't actually do math and go backwards, Michael, so I try, but
we have a stats guy.
You have a stats guy. I give you the credit. But what we also do in Baltimore is and my leader is here today, Paul DeWolf, who's the head public defender from the Maryland Office of the Public Defender, came up with the brainchild for my unit, which is the Director of Special Litigation. And what we do is we go backwards and we mine tainted convictions and we work with the state's attorney's office, but we also have what we try to think is a heavy presence in the courtroom going forward to keep this kind of atrocity from happening again, because what we know is that police officers are allowed to engage in this type of practice undercover, right? Undercover of LEOBR, which is the Law Enforcement Officers' Bill of Rights. They have very powerful unions and they keep those personnel records locked under secret. And when we get them and we expose them, this happens. This baby in LaRonde, when I started in Baltimore City, and I don't know if my time is quite up yet, but one of the most notorious, we were spread up in jurisdictions. I was in the Southwest jurisdiction. Every other Southwest client I interacted with told me about this guy. I just listened to the clients and we filed for his internal affairs records. Miraculously, somehow we finally got in. They spanned over the course of several years. When we had a 2-day hearing, not one, it took 2 days full of hearings to get through his IAD files to figure out what we could possibly bring into court at trial. He melted entirely in court. He pulled out his cell phone. It was during Freddie Gray. Cops were everywhere. He started to videotape our witness. There was a reporter who caught it. They took him into custody. They banged on the courtroom. They said, everybody's sequestered. Mr. LaRonde's in witness protection. I was like, what? That's kind of awesome. Then we didn't stop there, and that was we didn't stop there. We obviously, the chief counsel for the state's attorney finally came in and dismissed the case. They were seeking a minimum mandatory drug penalty for our client, 10 years without the possibility of parole. We didn't stop there at the public defender's office. We joined with the private bar and we filed all of his open cases, motions for his internal affairs, so everybody had access. Mine might have been under protective order for me, but we felt like everybody was entitled to know. So we took our motion, we springboarded it into the community, and the next thing you know, he separated from the police force. Finally, somehow, miraculously, the trial board decided to terminate him. We did it again in another case recently in Baltimore City, a notorious officer, again, same thing, client after client after client. We filed for his. We went in to litigate. The state's attorney was like, okay, fine. We might have not disclosed anything before, but we'll give you 6. There's 6 files you're entitled to in discovery. We're like, yeah, we don't think so. We're going to go one by one, Judge, and let you know what we think we're entitled to. On the day the order came out, we were so excited. He's ruled. Holy Lord, not 6, but 13 files he says we're entitled to. And oh my God, they go back to 2007, but it didn't stop there. 33 files that had never previously been disclosed we got from that particular officer, who, by the way, in his files, every time he beat somebody, he called Crime Lab. And so he wanted to get these trophies for the people who he beat with his walkie-talkie. I can tell you now because he was actually so arrogant, he came in to testify in person at his 608B hearing where we got to talk about what we get to use at trial, and we convinced the judge, you can't be complicit anymore with this misconduct in Baltimore, open up the courtroom. And so he did, so we got all these pictures on the record. We won the hearing, and the cop said, I still want to testify. We were like, all right, buddy, we won. We established a reasonable factual basis to answer the question. You're not going to overturn that, but go ahead and testify. So he did, so we got all these documents in of the people who he beat, and the next thing you know, the state's attorney's office had to send an investigator to find him, to subpoena him to come in and testify in every single open case he had after that fact. Not surprisingly, he's not there any longer. So what we try to talk about in Baltimore is how to keep it from going forward. And so why I'm so excited to be here today is because, for me, I'm hearing people say protective orders and IAD files. I'm like, everybody in the room knows what an IAD file is? This is exciting to me. And talking about strategies for building databases. In our special litigation section, and I'll wrap up real quick, which again is the brainchild of Paul DeWolf, who's here today, in the last year we've won over access to at least 20 cases where we've gotten access into never previously disclosed IAD files. In fact, we sparked a complete open file access that's going on in Baltimore, where we're now invited to come to the prosecutor's office and look at all of the files for every officer. We're working out some kinks because, candidly, the way they do it breaks the law, and we don't want to do that. So until they fix that, we're not going to participate. But we're getting there where we're trying to fix it. We litigate across this, we join forces across the city. You've got this cop, you've got this cop, you've got this cop. How can we work together to impeach him on the stand for his misconduct and quite frankly embarrass him and make sure that it doesn't happen again? We also go backwards and we undo convictions from the gun trace task force. So far we've done 300. We work with the state's attorney's office. Where we agree on materiality, they're willing to undo convictions without a fight. Where we disagree is when they don't show up in the police report. But for us, and for those of you from Baltimore who are listening, what we found in a couple different cases, in fact, an attempted murder that just got dismissed last week for a discovery violation. It was my case with my colleague John Marcus, attempted murder. All the officers who originally responded were gun trace task force. State's attorney's office said we don't need them. They weren't important in the case. Well, we disagree. They're there, and when they're there, the conviction's tainted. Well, we don't agree. We don't agree. We're in the middle of trial, discovery violation. Lo and behold, a 30-minute surveillance video that was never turned over that shows the gun trace task force officers walking around kicking DNA evidence that they were using to convict our client where we were arguing blood transfer. Just brazenly on the crime scene in mass without appearing in the statement of charges. So we argue every time they're there, these officers don't have on-off buttons for integrity, right? They just don't have it when they've gotten to that point. And so we challenge every single case that they've touched. And we're working to do more. And at that, I will turn it over to Brad, to Josh, who's done way more than me.
I mean, that's insane. If you're going to refer to yourself as the baby attorney, then I don't think I make it out of utero because I think we're at about 30, and I think she's at 300. So thank you for helping me with this, but there we go. So I'm going to tell my story, and I'm from the Exoneration Project, and I've been doing this work for about a decade. Well, I say this work, but really what I was doing is what Tara, Eva, and others have talked about, is I was investigating cases one by one. Someone would claim they were innocent, and I would try to investigate it, sometimes win, sometimes lose. So I came to this work through that process, through working on a case called, and I do think this is a very different type of work, a case named Ben Baker. And to summarize it really quickly, Ben Baker was arrested in March 2005, had a trial in 2006 where he testified a sergeant named Ronald Watts framed him. But Watts wasn't the only one. There were 3 other people who testified in Ben Baker's case. 3 officers who, when I got the case in 2015, were still on the force at that point, still making arrests, still testifying in court every single day. I learned Ben was still sitting in prison. I learned when I got the case that Sergeant Watts had actually been arrested by the feds in 2013 and convicted in 2014. He was arrested for stealing $5,200 from an FBI confidential undercover informant. And he was sentenced to 22 months. So I look at that and I'm pretty naive and I'm like, why is Ben Baker still in prison? I don't get it. So I was basically trying to look at 2 different things. Oh, I gave him the wrong one, but that's okay. I was basically looking at 3 different things is what I wanted to know. I wanted to know, well, how long, is this the only time? Peter mentioned it. Is this the only time that Watts did this? So I was looking for information, did that happen? I wanted to know, were other people involved? Because like I said, those 3 other officers were still on the force, and I want to know if those other people were involved, if this wasn't the only time that Watts did this, stealing $5,200, if he had also, by the way, framed people, not just stolen money from them, was it going on back at the time that Ben Baker had testified to this going on, so back in 2005 or before. So what did I do? I mined the data we've been talking about as much as I could. I looked first at the Watts federal criminal case. What did the U.S. attorneys, what did the defense attorneys have to say about it? Watts was brought down with one other guy of his team of about, I don't know, 2 dozen, it could be a dozen, could be a dozen and a half. But one guy named Khalid Muhammad. So what did the U.S. attorney have to say about it? He said that they said in their sentencing memorandum, he did this twice, Watts, with apparently no second thoughts from what we see on the recording, which leads you to leave you to wonder how many times he might have done something similar when the government was not involved. The U.S. attorney was speculating maybe this wasn't the only time that Watts had done this. That's interesting. Next thing we did is we tried to FOIA. We call it FOIA in Chicago, Freedom of Information Act, all of the federal documents, the FBI investigation that led into the Watts indictment. That was really interesting. First they said, no, you get nothing. So we sued. And then we started to get some. They said, you can get some of the stuff. Highly, highly redacted. And what we learned was extraordinary in that. We learned that the FBI essentially conducted 2 different investigations. It started in 2004 and went through 2006 when they stopped. They stopped seemingly, reading between the lines, because the Cook County State's Attorney's Office said, you know what, we got this, we will investigate, we got this. So they stopped. And then nothing really happened for about 18 months, so then what we learned at this point was from 2007 to 2012, they picked it up again. So this is one count that leads to a conviction of 22 months and 18 months for Watts' co-defendant, Khalid Muhammad, that we learned was actually at least an 8-year investigation. They got one count on 5,200. Well, what did some of those documents say? Well, it looked like what I was looking for, along with other members of his team. Buried in these thousands and thousands of pages of documents, those were the kind of quotes I was looking at. They routinely used their positions as officers to extort individuals at Ivy Wells. That's exactly what I was looking for, right? Other members of the team, not just Watts and Muhammad, all the names of those other members of the team were redacted and all this, and routinely. It wasn't just once. It went on and on. So next thing we looked at is, as people have talked about, the civil suits. In this case, it was extraordinary. About the same time it was going on, 2 Chicago Police Department, about the same time that I was re-investigating this, and Tara's exactly right, everyone else knew about it, just lawyers like us had no idea. But 2 Chicago police officers, whistleblowing Chicago police officers, had sued the very high-ranking Chicago Police Department in the city of Chicago. They had an ongoing whistleblowing lawsuit. And you may have heard of the whistleblowing lawsuit because this was the case where Rahm Emanuel, our mayor, was subpoenaed to testify about a code of silence in the city of Chicago and was set to testify, except for it settled on the day of trial or the day before trial. So that whistleblowing lawsuit was actually whistleblowing because they were involved in the joint investigation with the FBI of this Watts investigation. So I went, and not only did I look at that settlement and leave it at there, but I looked at all the underlying discovery, and I got everything I could, including the depositions of the whistleblowers. So these are whistleblowing officers, and they said, well, what did they say about it? Well, overwhelmingly, these huge 8-hour depositions said almost nothing about it because it was assumed that Watson was corrupt, and it was really just about their retaliation that they faced. But buried in there were some really, really great quotes. Shannon Spalding said stuff like, she was talking about her retaliation, and she said, well, you've made a complete false allegation about me while all the other members of Watts' crew are still on the force and still making arrests to this day. That's awful. Then Dan Echevarria, the other plaintiff in that case, and said, and once we were in the FBI, we knew for sure that the department was well aware of what Ronald Watts was doing along with others, those three words that were really important to me. How long had it been going on? Damn near a decade. This is in 2013 when the arrest happened, so now we're going back 2003, if not before. So then we were able to find another whistleblower, a guy named Pete Kachonis, who was given to us, worked at IAD for a really long time, and said, you know what, I'm going to put the names with you for at least some of them. He's like, I didn't do this investigation, but I had been in the Chicago Police Department Internal Affairs Division for a really, really long time. I was consulted on this investigation. I can tell you some of those redacted names in the FBI reports. I'm willing to do it. Here they are. Brian Bolton, Robert Gonzalez, Alvin Jones, Douglas Nichols were some of them that I knew were working in consort with Watts and Muhammad, still on the force. The key, again, at this point, I'm only worried about Ben Baker. That's all I'm thinking about. The key to me was that Douglas Nichols, Alvin Jones, and Robert Gonzalez all testified in Ben Baker's case. Those were the 3 other officers who testified along with Watts. So the last piece of information that was crucial to me, I got really lucky, and there was been about 10 years of litigation by a guy named Jamie Calvin in the city of Chicago about whether or not complaints of Chicago Police Department officers are public. And right about the time when I was doing all this, the litigation finally completed and it became public information, which meant I could FOIA and get the summary digest, at least the summaries, of all the complaints against Watts and his team, which is exactly what I did. I did them one by one. And then I listed them. And these are just the ones that are relevant. There's a lot here on this page, right? These are just ones where people complained that they had been framed, planted drugs on them, or something close to that. And there was a lot more. So this is a lot, right? Oh, wait, there's more. Oh, wait, there's more. Oh, wait. So this was going on. And then we discovered some real problems in the way that Chicago, all these, by the way, were unsustained by the Chicago Police Department and the Office of Professional Standards about they really happened. But these were fun. These were ones where Watts was complained against in the Chicago Police Department, or Office of Professional Standards assigned Watts to investigate complaints against himself. So those were fun. So we had a little list of that. So anyway, so I put all this information together, filed my supplemental pleading in December of 2015 for Ben Baker. I called that, this is before Ms. Fox's administration. I call the highest person I know in the state's attorney's office who will take my call. I say, by the way, I'm going to file something. I think it's going to be kind of interesting for you. You might want to take a look at it. He said, okay. I filed it on December 15th, and 29 days later, they agreed that Ben Baker should walk out of prison. In this type of work, that's pretty extraordinary. It doesn't happen in 29 days very often. So I was like, okay, that's good. That's interesting. Well, let's start to think about what's next. Well, Ben had another case. While he was on bond in March of 2005, they planted another case because Ben was trying to expose them, and they were retaliating against him for attempting to expose him. Am I running out of time?
No, go ahead.
Okay. They were retaliating him for attempting to expose him. As soon as you file a complaint, the police officer learns who the complainant is, and these officers would routinely go back and retaliate against them. So I was like, okay, well, Ben and his wife were retaliated against, and they had ended up pleading guilty because they were in front of the same judge who had just ruled that he didn't believe Ben, he believed the other 4 officers, so they were forced to plead guilty. So I gave it a shot. We don't usually are able to undo guilty pleas in Chicago. There's not. It's more stretched. There's no jurisdiction, these types of problems that we have. I said, let's file. So I filed. 6 days later, the Cook County State's Attorney's Office, still under Ms. Alvarez, agreed to drop it. I'm like, okay, it looks like we have some agreement here. We did it again. Rhino White, this was the next one. This wasn't really Watts as much. This was a guy named Alvin Jones. Jones was one of them. Pete Cachonis mentioned, who was still on the force. He was a sergeant. But White's complaint was really about Jones. 2 minutes. White pled guilty at his first court date, but when he did, he said, you know what, I'm pleading guilty because I'm scared. They put all this drugs on me. My public defender's telling me I'm getting life if I go to trial. I didn't do it. They framed me, but I'll plead guilty. The judge said, sure, go ahead and plead guilty. That's fine. We're all good. I took this. I said, I got the guilty plea transcript, put it to the court. Didn't take long. Everyone agreed they need to dismiss White. So I was like, all right, we got something here. We're all in agreement. I said, let's do this differently. I filed this thing. This is right when Eric and Kim and I made their life miserable. Ms. Fox started coming on board. I said, I can't keep doing this. All these people are contacting me all at this point. We need to appoint a special master who's going to do this for me. The key, these are all the things. How many people are there? There could be 500, could be more. Who knows? Let's fix them all. Judge didn't really like that idea, so I ended up changing strategies, and I ended up just saying, screw it, I'll do it myself. And I just sort of, one by one, have retained clients as they come to me and investigated them, got affidavits, corroborated those affidavits when I can with police reports, other statements, who else they told, filed complaints, guilty plea transcripts, trials, whatever it is, and ended up filing this petition. And I filed in September of 2017, and for a while we were fighting about whether this was even appropriate. No one had ever filed 15 different criminal cases in one proceeding, at one point, 18 convictions in one proceeding, and we were fighting about whether this was even proper to do. And I wrote Eric a message. I remember Mr. Sussman a message like a week before, and I was like, I know we're fighting about procedure. That's fine. I get it. But by the way, like a lot of these guys outcried, just like White, Baker, Glenn, all these other people filed CRs, testified about this. You should dismiss. And I was surprised a couple days later when he called me and said, you know what, we're just dismissing them all. And so on November 16th, they dismissed all. Since then, 15 cops have been put on desk duty, so all those cops who are still in the force are no longer making arrests and testifying in our court. We are working with the state's attorney's office extrajudicially now. I have something like 60 or 80 clients that I give them at a time. Now, I will say that we still have some disagreements, and I think it's fair. What you heard from Baltimore, I want to point out just one distinction between Baltimore and Philadelphia and what we're doing, is I don't have access to the data. I'm private, they're public. My position has been that all these cases are tainted, but the way we've been doing it so far is they're coming to me and I'm going to the state's attorney's office and I'm investigating them. I mean, I'm doing a real investigation, giving a narrative of each of their claims of why they were framed. My position has been that the data should go backwards. The data we should be finding out all of these people with the arrest. I don't have access to data, and we should go back and find them, and we should be dismissing those cases if they meet the standard that Brad described, what I think the state's attorney's standard is, although it's like the Coca-Cola secret. But anyway, so that's my little story of what's been going on. Well, sorry, did I go too long?
Before Matt starts, I had to, whatever happened to your motion to appoint the special master?
The judge, I withdrew it when...
Well, did the district attorney's office join in it?
The district attorney's office, and maybe Eric will talk about it a little during his panel, we worked together, we decided we
I understand
work
that.
together for it.
We tried to do it, we couldn't get funding.
We couldn't get funding, that's true.
Well, that's an important point, yeah. In trying to think about the most rational way to go about doing this, if one could. All right, well, talking about a rational way to go about investigating a lot of cases, Matthew.
By the way, they're all flat.
Thank you, Barry, and thanks for everybody. I want to thank Villanova for hosting this and all the people who helped put this together. I sort of like Debbie said, when you get the call from Barry or anyone else saying, here, come here, it's like you're being, someone calls you and say, would you like courtside seats to NBA All-Star Weekend, but instead of NBA All-Star Weekend, it's Wrongful Conviction All-Star Weekend. And yes, I would want those seats, even if it means talking. So I do not have a PowerPoint presentation. You will have to. I will have to try to paint a picture with words. Here it goes. One of the things you've heard that's a recurring theme in the presentation so far is uncovering bad facts, right? Really bad stuff has happened. Maybe some people know about it, maybe the community knows about it, but there are really bad facts out there. And when it comes to these lab scandals that we've been litigating in Massachusetts, that's how they are perceived from the outside. These are cases about bad facts. They're specifically about bad chemistry. And what we have been working on, you heard a little bit from Carl Williams, we've worked in tandem with the public defenders in Massachusetts for a while, and with law firms Foley Hoag and Fick and Marks, is that we actually thought that with scandals of this size, the real problem was bad law. And you heard a little bit about that from Josh, right? You're having to invent some kind of petition to file or a motion for a special master when you have more cases than you sort of know what to do with. And we knew from the beginning that we were going to have more cases than we could possibly litigate one at a time. And so the whole animating principle for us has been to turn bad law into good law. And specifically, the thing that we always think about is the burden of a systemic injustice shouldn't fall on its victims. You know, congratulations, you've been wrongfully convicted. You've got to find out that that's true. You've got to find out the facts. You've got to get a lawyer. You've got to file a motion times 30,000. And by the way, there aren't enough lawyers in the state to do that. So so to understand the action of bad law on people's lives, I want to tell you about a couple of our clients. We filed petitions in Massachusetts on behalf of individuals, but also on behalf of an organization. We've joined with public defenders. Our two clients in one of the cases we're working on right now in the Amherst Lab scandal are Nicole Westcott and Herschel Reeves. Both Nicole and Herschel have drug possession convictions in their past. And as you know from doing this work, you know that they don't stay past, right? There are people who are suffering every day with the crippling collateral consequences of those convictions, trying to turn their lives around. And they're living every day. So I want you to understand the bad law problem. I want you to think about what's going on in their lives as I tell you what happened in Massachusetts. So in August 2012, it was disclosed that a chemist named Annie Dukin at the Hinton Lab in Jamaica Plain, which is on the eastern side of Massachusetts, had been engaging in all sorts of misconduct. She disclosed. And really, it's framing people. She said she was supposed to test drugs to see whether it's really cocaine, whether it's really heroin, but she wasn't doing that. She was also forging people's signatures. She was doing all the things, possibly even putting her thumb literally on the scales. Not good. And so that was disclosed to the public in August 2012. Just a few months later, in January 2013, another chemist in Massachusetts was found to have committed misconduct. A chemist named Sonia Farrick in the western part of the state working at the Amherst Drug Lab was arrested for tampering with samples. And in her instance, it was that she was herself suffering from drug addiction and was using and even manufacturing drugs at the lab, using drugs on a daily basis while testing drugs in cases that put people to jail. And when these facts came out, this is what the people in charge said. When Dukin was arrested, there was a statement put out by the District Attorneys Association that their primary concern was to do justice. That was going to be their principle. When Farrick was arrested, the district attorneys put out a statement that said they're going to be proactive in identifying cases and notifying defense counsel and bringing them affirmatively to the court. And the Attorney General's office also put out a statement that said, well, luckily, the Farrick scandal is very limited in duration and affects only a handful of cases. And that's true, that all happened, and I'm done. Actually, none of that happened. And what ended up happening instead is that people were not told. So when Sonia Farrick was arrested in January 2013, and our clients, Nicole and Herschel, are trying to overcome their addiction, get clean, move on with their lives, get jobs, they didn't get a letter that Farrick had in fact worked on their cases. District attorneys didn't bring them to court. District attorneys didn't try to undo their convictions. None of that happened. And so we were part of a series of cases. And here I have to give credit to the district attorneys who helped us come up with some of these ideas, because the very first case was a special petition filed with the state Supreme Court, which in Massachusetts, because we like great titles, is called the Supreme Judicial Court. The very first case seeking a special rule for all drug cases was filed by the district attorney for Essex County, filed a series of petitions saying basically there shouldn't be any special procedures to help facilitate these cases, and everyone should have to serve out their sentence, for those who are incarcerated, while they litigate their case. They shouldn't get a stay of their sentence, they should stay in. And we thought, well, gee, the special petition seems like a really good idea. So what we have done since 2013 is file a series of cases that are designed to change the law governing how these cases are litigated. So in the short time we have here, I don't want to get into everything, but I will just mention a few things. That way, hopefully I can talk to some of you afterwards to see whether these kinds of things might work where you are. But we filed, next month I'll be arguing my fourth case at the Massachusetts SJC on these issues. So there's been a variety of cases, but so let me tell you generally what happened. We filed a case on the Dukin scandal, the Hinton Lab scandal, in January 2014. We filed a case on the Amherst Lab scandal in September 2017. And here's the kinds of rules that we got out of this. One was a presumption, this is not our case, this is someone else's great work, a presumption of misconduct by Annie Dukin in every case. You did not, after this decision, you did not have to prove that Dukin committed misconduct in your case. It was assumed. There was, the second really great rule we got was an exposure cap. There was a guy who actually challenged his Dukin conviction, got his conviction vacated. The DA resuscitated previously dismissed counts that had been dismissed as part of a plea agreement. He had to go to trial on those counts. He was convicted this time to harsher charges and was sentenced to more time than he had to serve before he had won the overturning of his wrongful conviction. And you can imagine the shockwave and chill that sent through every single person who was even thinking about challenging their wrongful conviction. So what we had to get was an exposure cap that said, there's no way, no matter what you can do, even if you go to trial this time and you previously pled, there's no way you can be convicted or sentenced to more time this time around. The second thing. Third thing that we got was in essence, now they actually call it a special master, before it was something else, but we got a special master to oversee the proceedings, to require the district attorneys to provide notice, to require them to create lists of the affected cases. One of the fun parts about my job and Carl's job is, like, occasionally we get CDs in the mail that have, lists of thousands of cases that are going to be dismissed, which is fun. That's more fun than the stuff that I usually get in the mail. And that is a consequence of this special master process. We also had things like notice, where who is going to, there was, on the first panel, there's a question about how are people going to find out. There's a requirement through the special master process that the district attorneys deliver notice, that it's agreed upon what the notice is going to say, that it's going to be paid for by the district attorneys, and it's not going to be just in mail, because the folks who we need to reach have to move a lot. They are poor. They might not get mail. They might not really trust mail that says, official document, really important for you to open this. They might think, well, I'm not sure if I want to open that document. So we also have had Facebook ads paid for by the district attorneys through the special master process, designed to tell people about the hotline at the public defender agency, where they can call to get attorneys and to learn their rights. And the other thing we got, and this goes to Peter's point in the prior panel, is data, right? So now we have, in this effort to identify people, we have some data on every criminal case involving a drug charge that's been filed in Massachusetts from 2004 to 2018. We have data on the Dukin cases. We have data on the Farrar case. This is useful data, among other things, that help people to get very comfortable with the idea of dismissing these cases. Because one of the things that the district attorney said, based on no evidence, was that these were the worst of the worst, and that we really needed to keep these convictions on the books. In fact, in May 2016, they wrote in a document that their strategy had been to protect the convictions. And one of the reasons why they said that was, why it seemed like that was their strategy, was that they wanted to portray these defendants as the worst of the worst. And we showed that we hired a data scientist to show that that was not true. In 60% of the Dukin cases, the only drug charge was for possession. In 90% of the cases, the entire case was prosecuted in district court. In Massachusetts, there are district courts, there are superior courts. Superior courts are where the more serious crimes go. And you know who makes the decision about whether a case goes in superior court or district court? It's the prosecutor. So in 90% of the cases, a district attorney had indicated that it was not one of the most serious cases. And we presented that evidence to the court, and that, I think, was very helpful. In fact, the data scientist is mentioned by name in one of the SJC's opinions, because her work was so influential. And then finally, going back to this point of the burden of the systemic lapse has to be borne by the state that created it and not the defendants. We got a 90-day deadline at the end of the Hinton Lab crisis, which said that the prosecutors had 90 days from a decision that was issued in January 2017, 90 days to identify which cases they were going to dismiss and which cases they wanted to keep. And for any case they wanted to keep, they had to certify that there was sufficient untainted evidence to secure the conviction. And even then, the defendant still gets to challenge it. So all of that, again, going to Debbie's point at the beginning of this panel, the resistance was not because the prosecutors we were dealing with were bad people. In fact, we had working groups where we met regularly with prosecutors, and we work with them very well. They want to do justice just like we do. Okay? So what the issue was that all these bad legal rules that we had to overcome created this enormous incentive for them not to help and to allow the convictions to stay on the books. And that resistance, that inertia in favor of allowing wrongful convictions to stay on the books is what was overcome by this series of opinions. It wasn't replacing prosecutors with better people. They were already good people, honestly. And so 90 days after that ruling came out, we got the list from the district attorneys, and the day after that, one order, a couple pages long, I think, saying dismiss with prejudice those cases on that list. The cases on that list, 21,839. So that was a good day. But I want to go back to Nicole and Herschel, because that was April 2017. At that point, we hadn't yet filed their case. There had been all this great law created. Still, not a soul had written them to tell them about their cases being affected by the other lab scandal. So even as all these cases were coming down, telling the district attorneys, you have to notify people, you have to do this, you have to do that, they were doing it only in one of the two scandals. And the other scandal was simply being left to fester. So we filed that case in September 2017 on behalf of Nicole, on behalf of Herschel, on behalf of a bar advocate organization, and now things are moving more quickly. And so now, just 2 days ago, we got another 2-page order, this time dismissing wrongful convictions. I think the number of convictions is over 11,000, but it's in about 7,700 cases, including Nicole's cases, including Herschel's case. So those are phone calls to make. But, our view is this is good law, but it's troubling that even as all these good things were happening, it still took a lawsuit on behalf of public defenders in the ACLU, Massachusetts, and the law firm Fick and Marks to actually get those same results in the other scandal. We still had to sue to make it happen, and our view is we should do a better job of putting ourselves out of business. So, because I have Trump to sue, so I have other things, and so what we're doing, in the argument that we're going to make next month, is to try to make these systems run more on their own. And to top it all off, everything I've told you to this point is really just about the bad chemistry and the bad law that came out of it. There's also misconduct by attorneys in our cases. When Nicole and Herschel were trying to turn their lives around, when they were getting clean in 2013 and 2014, remember I said that the Attorney General's office had said that the misconduct was limited in time. Well, it wasn't. It went on for years with Sonia Farrick. And the Attorney General's office had in its possession in early 2013 a document that, if it had been disclosed to the defense, would have revealed all that. It was a diary with a company called ServiceNet, where Sonia Farrick had been keeping some record about her own use of drugs at the lab. It was the most important document that the Attorney General's office had. They didn't turn it over. They didn't turn it over. They didn't turn it over. And it took an amazing job by an attorney named Luke Ryan to find that document. And even after he found it, and he wrote an appropriately alarmed letter to the Attorney General's office in November 2014 saying, you really messed up, this is really bad, you've made false representations to a court about the extent of this misconduct. The very next month, one of these cases was argued at our state Supreme Court, and nobody on behalf of the Commonwealth mentioned to that court that everything it had represented to the lower courts about the scope of the misconduct was false. So that would have been helpful information for Nicole and Herschel to know in 2014. So next month, we're going back in front of the state Supreme Court. We've now had these 7,700 convictions overturned in the Amherst Lab crisis. But what we want is something more. First of all, we think that the entire lab's cases are suspect for reasons I don't want to get into right now. The second thing is there should be standing orders, not routine lawsuits by the ACLU and public defenders that require these kinds of rules to go into effect. You learn about misconduct in your case, you got 90 days to tell the defendants whether you're keeping their case or not. And there should be some more accountability for when lawyers participate in this wrongdoing. Every conviction, overturned conviction I've told you about, that's not accountability for the Attorney General's office, which committed misconduct. So we're also seeking some standing orders and some monetary sanctions that would go to that problem. But for now, this is a nice beginning to a week after being able to tell Nicole and Herschel not only that their convictions are overturned, but that they brought a case that had this result. And I think that goes to the community point that a lot of folks have been raised. It's not really my case or Carl's case. It's Nicole's case and Herschel's case that just resulted in this massive wave of justice.
Okay, quite something. And the cases that involve the misconduct by the prosecutors that didn't disclose, those are being dismissed without any kind of, you don't have to go back and show prejudice in those cases?
Arguably, our case is one where that question is going to be raised, but Luke Ryan and some other attorneys had a series of hearings out in Western Massachusetts, and now, as a result of the judges finding in those cases of egregious misconduct, the Attorney General's office is no longer contesting that the misconduct occurred.
Right. So let's turn for some questions. Okay, let's do that. No questions? It was so overwhelming. Vanessa.
You said that document that wasn't turned over wasn't... The document that wasn't turned over until one of the lawyers discovered it. I was curious as to how the lawyer discovered it to give us ideas about how everyone might find similar hidden documents that we need.
Well, his story is one of perseverance. I can't probably do it justice here, but basically the way that it worked was the Attorney General's office was prosecuting Annie Dukin and Sonia Farrick, and the way that the evidence train was supposed to work was they were supposed to turn over the evidence that they got in the course of those prosecutions to the district attorneys, so the district attorneys could then turn it over to defendants. And what Luke and others did was they filed a series of subpoenas and motions directed at the Attorney General's office, and they just kept pushing it, even after they had been told falsely and repeatedly that they were on a fishing expedition, that the misconduct by Farrick lasted just a few months, and they just kept going until a judge allowed them access to the files, and then it was pouring through those files that we found this document.
Let me ask a question. Let me be honest, it's not so much a question as posing a hypothetical of a different kind of approach to these things. Not different, but let's say that the public defender offices in different jurisdictions had the kind of databases that were being described as Philadelphia's building. I can tell you that in New York City, the Legal Aid Society has a database where they track every finding of false statement by a police officer in a reported or unreported case. They track overtime, which, as any police manager will tell you, is a critical one to look at because you will begin to identify the officers that are making the most arrests and people that you should watch. We've talked about videos. Debbie was, I guess, showing one, and we had others that you might have seen recently in the New York Times in Los Angeles. There's an incredible one from a body cam where an officer is putting a baggie of drugs into the wallet of the man who's being arrested, not knowing that the body cam is actually rolling, and things of that, and any transcript where you have these false statements of officers. All these things are being put into the database now in New York, and I'm sure in Philadelphia and other places. Let's say also that the private bar, right, is able to crowdsource and get access, contribute their, I mean, I know that in Philadelphia, they would just call Brad. And they tell him about it, and because the rules are not as crazy as they are in other jurisdictions, when they ask for information about an officer, you could just give it to them. That's what's been described here, and that is not the law in many other jurisdictions, as Debbie was indicating about Maryland. It's not quite the law, I don't think, in Chicago. It certainly isn't the law in New York. And by the way, Dave, when you get up here, Dave Laban can tell us about the worst of all, which is definitely California, where not even the prosecutors under Pitch's motions get access. But let's just envision that the defense has that kind of robust database. Let's envision defender offices that practice what's called holistic representation. That is, they have real ties to the communities. You know, they do immigration cases, they do civil litigation, they are tied into the community, and all the information that the clients are saying can actually be inputted into a database when you begin to look at scripts of suspicious stories that are repeated again and again, and information about bad officers. Let's assume also that you have newspaper stories about officers that are put in. Let's assume further that people are looking at social media and they're finding statements by police officers, and it could be prosecutors, other law enforcement officials in social media that merit attention because they may indicate some kind of bias, right, that you wouldn't want in law enforcement officials. Let's assume that all this kind of data is crowdsourced, and we know that the capability now is out there to do it. Would that not in turn, if you got it, change the behavior of prosecutors? Because they too would begin to look for the same kind of data, because they know that when the defender is coming into court, they're going to say, here's an officer, I have all the civilian complaints, substantiated, unsubstantiated, I have the civil statements, I have all the statements of when they didn't tell the truth. Would that not put pressure on prosecutors? And I'm not just talking about the progressive prosecutors that have been elected in jurisdictions, but in other places, to begin to gather that data as they should internally. And would that not also assist our friends in the police departments who, if we're really honest about all of this, have the toughest job? Because ultimately, when it comes to internal affairs or investigations, you have officers on the street. One particular day, somebody saves your life, right? Has your back, and then the next day, you know, they just lied in a police report, or they embellished, or they did something that was maybe an example of excessive force. And now you're in a position where you may have to report them. That is not easy. Let's be honest about all of this. So imagine if we used big data to crowdsource this kind of information, and people were working together, both the public defender's offices and the private bar. Would that not do something quite extraordinary? I'll leave it at this. There was one of the things that illustrates all of this is a recent arrest of a police officer in New York City. Amazingly enough, it was prosecuted in the borough of Queens, which is not known as a borough that would ever bring such a kind of prosecution. But it involved this officer, and you can see it in the New York Times stories by Joe Goldstein about it, where literally there was a videotape of him in a bodega, right? And he had claimed that all kinds of an incident had happened in the bodega that justified him walking outside and conducting a stop, frisk, and search of an individual. The video in the bodega showed that nothing happened, right? because the video is so powerful, they prosecuted him. He also had the biggest overtime of any cop you can imagine. They prosecuted him for perjury in Queens. His defense lawyer got up and said, in closing argument, if you prosecute him for this, for perjury, for this kind of quote-unquote white lie, right, we're going to have so many perjury prosecutions about it, we won't know where it will stop, right? His partner, by the way, that had to know this, the judge, it was a judge trial, just dismissed her case. So she never even got prosecuted. He got convicted. Then at the time of sentencing, that same defense lawyer got up and said, this now sends a signal. The detective, this decorated detective, is driving an Uber. He's off the force. This now sends a signal to every police officer in the city of New York that if you embellish even a little bit, you could be prosecuted for perjury, right? And it had enormous deterrent effect. And the judge sentenced him to probation and a $500 fine. But that is actually a real illustration of how gathering this big data, and as Peter said, even tracking racial aspects to that data, and developing new institutions and new rules, as Matthew's explaining, whether it's conviction integrity unit or special masters or some independent way of doing this, we're really on the verge of something quite dramatic. And so I thank all the people from the Exoneration Initiative and Villanova for pulling this conference together. Plainly, this is only the beginning, and we're just at lunch, right? About to hear from the most interesting and district attorney in the United States.
All right, well, thank you all very much.